I'm really delighted to be here tonight to chair this panel event, which has been organised by various chambers together with the Revenue Bar Association and Lincoln's Inn, to tell you all a bit more about practice as a barrister in the specialist fields of media, company and IP and tax law. I think this might be the first time that a group of different specialist practice areas have got together like this. And they're doing so in recognition of the importance of attracting a wide and diverse range of talented lawyers to the specialist bar. They're all really exciting and interesting fields of practice. And as you'll shortly hear from the panel members around me, their chambers take on people from a wide range of backgrounds. I'd love to see that reflected in the barristers appearing in my courtroom. That's slowly happening, but it does need to gather momentum. And as you'll know, the judiciary at all levels are actively encouraging diversity outreach to aspiring barristers at events like this. And that's not least because the barristers appearing in front of us today are, of course, a significant part of the pipeline to becoming the judges of the future. So attracting a diverse judiciary a few decades down the line means starting with a diverse set of pupils at chambers like those represented here tonight. So this is my pitch for you all, not only to think seriously about applying for pupillage in the fields that we're going to be discussing tonight, but also to have at the back of your minds that one or more of you might be sitting in my lovely room in the Rolls building in 30 years' time. In the meantime, please do consider applying for the High Court Judicial Assistance Scheme for the next legal year, 2025-26. Applications open on Valentine's Day. So if you haven't got a date, you can sit down and write yours in the evening. And a link with details will be circulated after this seminar. And if you want to hear more about that scheme, you can talk to me afterwards, or you can ask Olivia also over drinks afterwards, because she was one of our recent judicial assistants. So thank you very much to everyone for organising this. And I'll now start with introductions to the various different specialist areas, starting with media. And I think Aidan's going to do that.
Yeah, well, hello, everyone. What's media law? Well, at the highest level of abstraction, it's a law that concerns the relationship between three sets of rights. Right to reputation and private life, right to freedom of expression, the right to a fair trial held in public. And at least two sets of those rights are at play in all the cases that we do at the media bar. Often it's all three. And the reason why I find it so fascinating and why I'm still interested in it after doing it for 20 plus years is that however you think those three sets of rights fit together, a new set of facts come along, everything's thrown into disarray, you have to rethink it again from the beginning, and you get a completely different result. But coming down from that high level of abstraction, media law, as we practice it at my chambers, 5RB, generally involves these things. First of all, we do civil claims for libel, misuse of private information, and harassment by publication. Sometimes that involves very high-profile cases, Wagatha Christie, the Johnny Depp libel, Prince Harry, etc. But other times we're acting for very ordinary individuals who've run into problems on social media or in workplace disputes. Secondly, increasingly we do Data Protection Act claims, either people attempting to find out what other people hold on them or stopping the dissemination of information. Thirdly, a lot of our work involves open justice, reporting the courts and contempt of court. For example, the recent Court of Appeal decision about the judge who withheld the names of other judges in the Sarah Sharif case. My colleague Sam was part of the team in that Court of Appeal hearing. And lastly, we do freedom of information cases. So what's attractive about this area? Well, it can take you anywhere in terms of the law and the facts. There's absolutely no limit on the way people find to defame, harass each other and to intrude on each other's private lives. Just to give you an example of stuff that I've had on my plate or got on my plate at the moment. A few weeks ago, I got Tommy Robinson sent to prison. I'm now doing a case about corruption in the Vatican, where I have to get my head around canon law and how it governs the way the Pope's advisors can invest money. I've got a case about whether Banksy has defamed a branding company by accusing them of exploiting his work for a fashion campaign. And I'm acting for Matt Hancock, the ex-health minister, who's being sued for a tweet he made accusing a vaccine skeptic MP of anti-Semitism. So all human life is here. Coming to the practicalities, I'll mention two things. First of all, almost all our work is in the High Court, and that's right from the beginning. You get on your feet as a second six pupil or a new tenant. That means you'll get noticed. You'll be mentioned in reserved judgments. You'll be in front of High Court judges. It's good for directories. It's good for developing your career to get on the Attorney General's panel, and eventually for silk and judicial appointments. Secondly, compared to other aspects of life at the bar, we spend a limited amount of time in court, compared, for example, to crime or family. Lots of the work is advisory. Some people make a living out of being the person who will do an injunction at any time of day or night at the shortest of notice. But it doesn't have to be like that. We have members of Chambers who have very good careers based almost entirely on pre-publication work, helping newspapers, broadcasters, filmmakers, and so on get their material safe for publication. And so it's a career where you can have very good flexibility if you need to accommodate personal commitments, family concerns, or any other reasons why you can't rush to court every day like criminal practitioners do. If you follow me so far and you're still interested, you'll be asking next, what's pupillage like and what's junior life like at the media bar? I'm not going to say anything about that. I'm a bit long in the tooth now, but my colleague Sam Rowe will give you some answers in the discussion bit of this panel.
Thank you very much. I'm really jealous. I want to go back and have my time again. Right, now Laura will sell you the tax bar.
I can't believe I have to follow Wagatha Christie and Prince Harry. It happened to me last week when I was in the Rolls building, and there were lots of press outside every morning. I turned up. My colleague over there, Jamie, was with me too, and they were all there for Prince Harry, not for us, but we enjoyed it nonetheless. So why tax? I'm one of the strange people who actively chose tax at the very beginning. Lots of people end up in it by accident, and that's also totally fine. We don't expect people to have any experience when they apply to us. We just want you to show that you've been interested in the subject and you've tried to find out a bit about it. Tax is an area of law which inevitably touches all aspects of life. So from the big multinational corporations to the family businesses and to individuals, whether they're high net worth or not. That means we get to advise or litigate on behalf of a huge variety of clients in completely different circumstances. So just to give you an idea of what I've been doing this week, I've had one discussion on a very high net worth divorce and the tax side of that. I'm working on a VAT appeal for a US investment bank. We had the first hearing the year before. I've been doing some very glamorous advice on landfill tax, which operates on landfill sites and actually turns out to be multi-million pound cases on many occasions. Other colleagues will have been doing totally different things. We sadly don't get to the state where we're allowed to name the names of many of the people we're advising because they tend to like to not end up in court if they're famous. But one of my colleagues has been doing the Gary Lineker case, which I'm sure you will all have heard about, and all of those IR35 employment BBC kind of cases are all tax cases. Tax is often focused on legal argument rather than being particularly fact heavy. We do, of course, care about the facts, but we don't tend to end up in 6-month-long hearings. We tend, the longest I've ever done is a 4-week hearing, and that's unusual. It's much more likely that you'd be doing 3 to 5 days in the first instance, and then shorter on appeal. We operate within a really extensive statutory code. So if you're the sort of person who likes a framework to start with before you delve into the detail of the cases, then tax is a really good option for you. I find I really like that, and I get overwhelmed if I'm working in an area that has none of that statutory framework, but other people love that. We I think it sounds a bit like media. You can choose whether you want to be very heavily advisory or whether you want to do lots of litigation. And that will change throughout your career. I started off being very advisory and now I'm much more in litigation. And I really enjoy that, and I really enjoyed that flexibility. We start in the tribunal system, so we have our first instance, the first tier tribunal, and then the upper tribunal, of which Mrs. Justice Bacon is our president. That's the same level as the High Court. So the judges that sit on that and the authorities that come out have exactly the same status as the High Court. But also our cases do often reach the highest courts because they tend to be about a large amount of money. So it's very normal to end up in the Court of Appeal, Supreme Court, and sadly no longer, but the Court of Justice of the European Union until very recently. So you get involved in those higher courts and you get to develop some pretty major principles as a result of that. I think that's probably enough on tax for now.
Thank you very much. Olivia, on company law.
Hi. So I'm Erskine Chambers' most recent tenant, and so Erskine Chambers is completely tied to company law. That is our primary specialism, and if you want to do company law, Erskine Chambers is the place to go. So company law itself, that involves both kind of corporate advisory work and litigation. So again, there's that dual kind of balance that you can have. You can do some more advisory, you can do some more litigation, you can do both. So that benefit also is something very much within company law. Then company law in itself is something that is much broader than you think. And you can just tell that if you go and look at the Companies Act, which is the longest act ever passed. And so there's very much lots of material within there, which gives you that kind of good legal variety. So even though you're specialists in that company law area, there's still many areas of the statute to explore. There's also very good factual variety. So people will come to Chambers with everyone from big multinational public companies all the way down to small one-man companies. So you have a kind of big variety there too. And then within the facts, there can be disputes between shareholders, disputes involving directors, disputes involving transactions between companies. So you can get kind of, some human interest when you've got that kind of knotty shareholder bit personal dispute. And then you can go to the share sale when you're looking at, facts, figures. There's all kinds of factual variety. And then alongside the kind of main company practice, there's obviously company law is not an island. So we also do work in associated fields, so insolvency and restructuring, general commercial litigation, financial services, and then kind of international and offshore work. So when I was doing pupillage, I was involved in a dispute on appeal from the Supreme Court of Bermuda, and members appear in the Privy Council. So if you're interested in offshore water work and kind of dream of your potential trip to the Caribbean for work purposes, then that's also an added benefit. And then Chambers itself, as I say, we're kind of the preeminent set for company law, but we're quite a small set, about 30 members, which allows us to maintain our expertise in our core practice areas. So we're kind of a tight-knit set. It's very easy to go and ask people for advice. But at the same time, because of our specialism, field effective teams in the commercial court and chancery division, Chambers itself is located in Temple, right next to the gardens, which in my view are the nicest in the gardens, and just a very pleasant place to work.
Thanks very much. And finally, last but not least, Jonathan, who's going to talk about IP.
So intellectual property covers a wide range of rights. There's the ones that everybody's heard of: patents, copyright, trademarks, but it goes a bit broader than that. One thing that's regularly litigated are called design rights, which are a close cousin of copyright, but there's a lot of fast fashion work that involves design rights. And indeed, the case that I was in when I was very junior that went up to the Supreme Court was about design rights in the trunky suitcase. Ever been through the airport and seen a trunky? There is a Supreme Court case on design rights. There's also confidential information. That's something that gets done at a number of areas of the bar, but there's a lot of confidential information work also done at the IP bar. Often tends to be slightly more technical in nature. One thing that has increasingly happened over the past 5 years, I would say, is a lot of it, we are an economy based around intellectual, or increasingly, I should say, based around intellectual property. So invariably, there has been a large surge in work related to that. And what that has led to is a lot of what I would call crossover work. So there's an awful lot of cases I'm involved in where there's competition cases, either the IP is a small aspect of that or the large aspect, but there's a competition counterclaim potentially. Tax, as Laura's mentioned already. Jamie, my colleague, who she was mentioning there, has been involved in that. I've been involved in a number of cases for HMRC. In fact, one case I've got at the minute is about whether confidential information is even a property right. That is debatable, and the outcome of what way the courts say could have very significant consequences. Obviously, large commercial disputes and also employment. There's an awful lot of my work at the minute is large employment type work where you've got restricted covenants, people have left, trading teams leaving banks, taking algorithms with them. You can see all the intellectual property rights there. That's often the bit that I deal with. Then you've got all the fiduciary duties of which I know nothing, so other people deal with that. So there's an awful lot of work which I find quite interesting because it means you are exposed to a lot of other areas of law. You don't just have to, you have to remind yourself of all those contract principles that you learned earlier on. The vast majority of work is in London. So 95% is in the Rolls building. And then there's another tranche of work which is in the intellectual property office that is trademark, and you can have patents and design stuff in there, but the vast majority of that is trademarks, and that's all about validity of trademarks. And that's one big boon, I think, of the IP bar in terms of advocacy. There's not a lot of advocacy at the junior end of the IP bar in the High Court, because generally our cases tend to be valuable, so people slightly more senior get instructed. But there's an awful lot of very junior and baby junior work in the IPO about validity of trademarks. So again, you get this nice runway of work as you ratchet up through seniority, and you're always doing advocacy. You're certainly not just stuck as a second or third junior on a large patent case. There is a nice gradation of work as you get more senior. As the type of work, it can be large companies, big pharma companies, through to famous individuals. The most interesting, nice and famous person I worked for was J.K. Rowling. When she started putting the Robert Galbraith books out, anybody who had ever written a whodunit tried to sue her for copyright infringement. So she had lots of claims brought against her, and that's what I was advising in relation to. Increasingly lots of tech companies, and probably the largest volume of litigation in the courts is actually trademark disputes. So people tend to think about patents. There are fewer cases of them, but they tend to be very valuable. But in terms of sheer number, I think trademark disputes, there's an awful lot of those. And again, it's just some examples of what I've been involved in. The biggest case I've been involved in recently was whether a man called Dr. Craig Wright was actually Satoshi Nakamoto, and whether he had, and that is the person who invented Bitcoin, the pseudonymous creator of Bitcoin. Turns out he's not. He's a massive fraudster and a liar.
That's in the official judgment.
That is an official judgment.
Mr. Justice Mellor.
Yeah, so, and it very unusual in a fraud. I mean, it was really a fraud case, and quite unusual in that in a fraud case, you tend not to announce the judgment, the result at the end of the trial. We were literally all packing up, doing the niceties at the end of a 6-week trial. And Mr. Justice Mellor just announced that he was not Satoshi and he was a liar, which was remarkably unusual, but it was because it was such a strong case. Another case I've been involved in involves a water rower rowing machine. And if you've ever seen that, or if you've watched House of Cards, famously appears in that. And that was a more intellectual copyright point about whether or not the water rower is protected by copyright, or whether it's protected by design right. And that may not seem substantial, but the difference is huge. Copyright protection lasts at most 25 years. Copyright protection, if those of you who studied it, lasts for the life of the author plus 70. So, and also there's a whole lot of other exclusions that go with it. So design and patent protection had expired and they're trying to protect it by copyright. So again, stuff like that. And then another case I've got involved in at the minute is about trading algorithms. So again, you're learning about fast trading algorithms and that sort of stuff. So very interesting. And often a very fun bit of IP is the subject matter is quite interesting. So it's legally quite interesting, but also the subject matter is quite interesting.
Thanks very much. So now you've had an introduction to various different areas of law. I'm going to ask a few questions, and I'm going to ask each of the panel members to answer. Let me start with the first question, and I'll ask Laura, and then we'll go around. Are there any myths or misconceptions about your area of law?
Yes, I think most people think it's about maths or numbers, and it has nothing to do with maths or numbers. In fact, you can be terrible at maths and be a great tax barrister. It is entirely about words. I mentioned that it's very statute heavy. There's a huge statutory framework. We can't claim to have the longest act. Was that what you said, Olivia? We can't claim to have the longest one. We've got a lot of them. And sometimes our job is narrowing down to one word and arguing about what one word was. In fact, I did a case in front of Mrs. Justice Bacon, which 2 words was about market value in the context of a particular statute. And in other cases, it's looking at a sort of jigsaw puzzle and piecing it all together. But we don't have to do the numbers. We're very lucky to be either instructed by accountants who will do that side of things for us if we need it, or we bring someone in if we're being instructed by solicitors who don't have that in-house capability. So I think that's the biggest one for tax.
Thanks. Sam, media.
Yes, I've got 2 myths. The first, unfortunately, Aidan has done a very bad job of dispelling with his very good introduction to media law, which is that media law concerns celebrities. Because although, yes, we have a large number of cases which involve high-profile individuals, organisations, etc., there are also a very large number of more run-of-the-mill cases. So, for example, a defamation claim arising from somebody writing a sort of horrendous insult about another person on Facebook, or conversely, a data protection claim arising from somebody's letter going astray and arriving with their neighbour. These are things that are the more prosaic matters, but will certainly still arise within media law. The second myth, the second misconception, not a myth, but more of a misconception to do with media law, is that there's no distinction between the sort of media law that's practiced at a set like 5RB and the sort of media law you might come across at a heavyweight IP set such as Jonathan's at. And so although there are members of my chambers who might do in practice some areas which might look like IP and might have trademark aspects and passing off and that sort of stuff, it's not our bread and butter. And I don't want to put words into Jonathan's mouth, but I'm sure that he would say that his bread and butter isn't defamation law, for example. So there's the myth and the misconception.
Thanks very much. Well, it seems I should go to Jonathan next. What about IP?
Yeah, I wouldn't touch defamation with a barge pole. No, there is definitely an overlap between the umbrella of media, but yes, I fully agree with what Sam was saying. The biggest myth for the IP bar is that you need a science degree. It's true that I would say the majority of practitioners at the IP bar do have some form of science background, but a number of my colleagues are here. I can see sitting up there. One has an engineering background, one had read English, and the other has a PhD in music. I myself did chemistry, so it's not essential at all. What I would say, though, is that if you do have a science background, it makes it a little bit easier to do patents, but that's only one aspect of the IP bar. And incorrectly, in my view, there is solicitors will often only instruct people who have a science background on a patent case, which isn't necessary. When I came to the bar, the best patent barrister was Simon Thorley, QC, and he had no technical background. So you don't need it at all. That is definitely the biggest myth. And another myth, not so much just for our area, but I have been asked a lot in the context of my area, but I think it applies more widely, is that you need to get to the bar young and early. Our pupils recently have been 30. I think the last 2 pupils were 30. The one before that was 23. There is no rush to get to the bar, and that's something that I was asked a lot. I don't know if that is more broad or just a particular problem with IP, but that is a myth that I certainly think isn't true. And actually, in many cases, and we might touch on this later, you're better just to get everything ready, get yourself set up, and apply when you're ready, rather than trying to rush in too early.
Great, thanks very much. Olivia.
So a misconception that people have said to me is like, oh, is that not quite a narrow area of law? And as I've already said, it's a very big act. So it's definitely not narrow in that respect. And I think that if you remember, companies are, the economy is, the companies are what the economy is, you're constantly interacting with companies all the time. And that's the kind of like external interaction where, you're interact with the company, but then there's also the internal element. There's directors, there's shareholders, and there's that kind of potential for internal dispute. So you've kind of got that kind of duality of the kind of like internal within the company and the external disputes that can happen related to companies. And then, as I mentioned, there's that you get that kind of factual diversity through the shareholder disputes, director disputes, transaction between companies. And then the myth that I get is that people think that that means there's absolutely, you don't get any kind of unled corporate work as a junior, which is not the case. There's lots of different applications you can do in the London County Court and as a junior. So you do get into court, you do get unled instructions, and it's not the case that you are kind of constantly working in lead work.
Thanks very much. So my next question, I'll start with Sam. We all know that it can be a challenge to balance a busy career with other aspects of life, whether that's your hobbies, your family, caring responsibilities, or just having fun, having a life. How do you fit it all in?
Yes, it's a very good question, and one that I'm sure all professional members of the bar in this room potentially struggle with at times. I personally make a very concerted effort when I make plans not to break them. That's the thing that I try and take very seriously, which might sound like a slightly frivolous thing, but in circumstances where you find yourself up against it in terms of time and knowing that there's a sort of a new brief has come in and there are 5 deadlines looming on the horizon, I try and distinguish, on the one hand, immediate deadlines, and then things which in the back of my mind I think are immediate deadlines, but in practice are actually deadlines that are going to be important in a few weeks' time, and I'm just thinking about them a lot now because they're in my mind. That enables me then to identify when a sort of commitment, pre-existing commitment, really does have to be broken, or whether it's just my own stress trying to feed into that, and in fact I can maintain it.
Thanks very much. Laura.
Okay, so I think there are some aspects of the tax bar which might be true of others here as well. It sounds like there is quite a lot of in common from what I've been hearing so far, but there's some aspects of the tax bar which I think are brilliant for life. Whatever else is going on in your life, they're just brilliant for it. One is that our 2 tribunals, the first tier and the upper tribunal, take into account counsel's availability when listing. So we never have to have the fight of, if I don't make myself available on that date, then this case is going to have to be handed over to another person, unless it gets really extreme. There was a point in my life when I was booking hearings up to 2 years on, and that got a bit silly. But the courts are incredibly accommodating to us. As I mentioned earlier, our hearings tend to be short, and the preparation for them can be quite extensive, which means you have this period, there's probably times when I'm in court once a month and it's for 2 or 3 days each time. I'm spending the rest of the month preparing, which means I know that I can have a social life during that bit of time, and that I just have to put that 2 or 3 days aside and say, realistically, I'll just be working solidly then. There's also the very crude thing, which is money. So when I'm standing up from behind this table, you'll all be able to see I'm expecting a baby, and this is my first, so I haven't done the logistics yet, but certainly colleagues have. And if you are in an area of the bar where you're earning enough money to pay for childcare support when you need it, that obviously makes a really big difference. I wish it wasn't that crude, but it's true. And all of those other things, flexibility that I've mentioned, will have a big impact on that too. If you know that your hearing is going to be 3 days and it's in a month's time, instead of being told you're in court tomorrow or you're in court next week, you can plan your childcare, whether it's family or paid childcare or whatever. You can plan your life.
Thanks very much. And I know we can do better on listing.
Yes, we've had a good chat about this, but no, and I think the tribunals, our tribunals, are excellent at it, and we've got one of our deputy senior clerk up there who can back me up on this later.
Thanks. So Olivia.
I think that there's kind of an ebb and flow with the work. So, some weeks you might have a very busy week, but then the next week might be a quiet week. And, in that quiet week, you can, that's the time to kind of do all of the hobbies that you make the most of it. And I enjoy that kind of ebb and flow, because, there's the pressure of a deadline isn't always bad. You kind of get that, push and the adrenaline, and then you can have a quiet week where you kind of enjoy the quiet week. And I personally think it's a very good lifestyle that I personally really enjoy. And I mean, compared to studying, I actually find it easier because you have that kind of, set task that you need to accomplish, and you can plan Also, I'd highlight that fundamentally you are self-employed, and because there's a large proportion of advisory work, and the advisory work proportion can change maybe depending on your preference. Doing that kind of work where you're not in court all the time means that you can have a bit more flexibility as to location, as to work hours, and I think that makes it a lot easier to fit in life things around your job. Yeah, so I mean, if you wanted to go for a run in your lunch break or even in the afternoon, as long as you didn't have an urgent deadline, you could do that. So I think that it's, there is definitely the flexibility in which to build your life into your job.
Thank you. And Jonathan.
So I think I'd emphasize that it changes very much as you get more senior in your practice. I think in your first 5 years, you probably have to sacrifice a bit more because you have to make yourself more available and you don't have that steady stream of work. You're not totally swamped, but there is that reality that you have to make yourself available to build up your practice over time. But then as you get more senior and move out of those first few years, and you get a more steady stream of work, it is much easier. And as Laura said, we are self-employed. My wife is a barrister at One Essex Court. We have a 2-year-old and a 4-year-old. And we both maintain full practices, but it doesn't, we have a nanny. There's no other way we could make it work. That's just something that we decided upon. And thankfully, we both, the nature of the work we do means we can afford that. And I think the other thing is, it becomes a lot easier as you become more senior because it becomes easier to push back. The biggest difficulty with our time is solicitors' demands on us. But the solicitors' demands ultimately come from their clients. So most of the deadlines, I think it's Sam or somebody else alluded to, was they're sort of self-imposed by the solicitors. We need this tomorrow, but that's because they've told the client. When we're very junior, it's more difficult to push back on that because you're scared. But as you get more senior, you realize slowly but surely that you can push back, and you'll find, I've certainly found, I hope, unless my career collapses overnight, but that the more I push back, is this really necessary? And actually, they are receptive to that. So it just requires a certain level of assertiveness. But again, being self-employed means you can tailor your work life sort of how you want. Many of these practice areas were not in court all the time. That makes it a lot easier. Prior to having children, I used to take 11 to 13 weeks of holiday a year. Which is great. I love skiing. I used to go skiing for 5 weeks a year. I have 2 kids now. That's never going to happen again. But many of the rest of the year, I was maybe working 6 days a week. I used to work regularly on Sunday. My wife and I would just do that. But we then took 4 weeks off in August every year and went away. So you can shift it around in our practice areas and you have a lot of control. So, but it's choosing to exercise that control. And when you are working. So it just takes a lot of discipline, but it's definitely doable and it's very rewarding.
Can I add one point from my own experience? Is that one person on the panel who has already popped out 2 kids. Personally, I was in a different specialist area of law, but had very many similarities to those which we've been talking about tonight, in the sense, not a very heavily court-based practice, time to do paperwork, a lot of flexibility. I found that having a partner who was willing to stay at home was my salvation, but we didn't have a nanny. So a lot of not very much sleep, but also I could leave work at 5 o'clock, and I did so ruthlessly until my youngest had got out of primary school. So that was about many years of leaving work at 5 o'clock come what may. And being very ruthless about scheduling diary commitments around being home in the evening. And also I took pretty much every school holiday until I came to the bench. So those are things that you can do. And as Laura said, having the money that you get from some areas of law does facilitate it. So I could afford to have a partner who stayed at home. My husband stayed at home for most of the time in the early years before going back to work. I could afford to take a reasonably good period of maternity leave without worrying too much. Obviously one is anxious if you're the only breadwinner in the house and you're off work for a year, but I was off work for a year with my second, and being able to take long holidays with the kids. It does make it work, I think, much more easily than many other professions, I think. So next question, let's go back along the line. So Jonathan, what's your top tip for preparing to apply for pupillage in your specialist area?
So I'd say we don't expect anybody to have studied IP before coming to the IP bar. In fact, the vast majority of people haven't. But we do expect to show a reasonable amount of interest in it. And probably the best way to do that if you're applying to one of the IP sets is to find a specific area or topic and just read into it a little bit more detail. Just having read up the generalities of patents, trademark, copyright isn't really going to show deep interest. But if you pick up something, I mean, at the minute, AI is the obvious one. There's the Getty Images case coming on in June, a trial in June, I think. So find something and then put that on your application, because we're almost certain, I'm not going to guarantee it, but we're most likely to ask about it. And that is a way that you can demonstrate an interest. And I think that probably applies to a lot of the areas here, is that you're going to be able to demonstrate interest in your area, but that is easier to be quite deep, albeit on a narrow area, and just read into something rather than trying to go scattergun across all areas.
Olivia.
I would definitely echo what Jonathan said. And I think the thing is you need to think carefully beforehand why you want to do that area. What is it about that area that appeals to you? And that doesn't mean you have to have studied it at university, but it does mean that you should look carefully at, Chambers' website. And there's lots of resources on there that you can look at to, firstly check whether you really are interested and then explain why you're interested. So we have a webinar series that you can look at, and it's very accessible. I actually watched lots of them before I started pupillage to try and get, into the right mindset. And that's a good way to kind of pick up stuff. It's sometimes easier to listen to someone speaking. And then there's lots of articles about recent cases. So it's easy to kind of, pick up a feel for the area. Then I'd also recommend, obviously, attending events like this. You've already kind of got ahead of the game because you've heard about these specialist areas, and hopefully that's given you an idea that you hopefully do want to do them. And then also, whilst it's not required for people applying to our chambers for pupillage, I would recommend doing a mini pupillage. It helps you get a feel for the set. And then if you have questions about the area, about the specialism, then you can ask them.
Laura. I'm probably going to repeat a lot of what both Johnny and Olivia have just said. Again, we don't care whether you've studied or had anything to do with tax. What we care about is that you can show that you have developed an interest in it in some way. That might have been sparked by absolutely anything. Could have been a news story, could have been a case you read in your trust law lectures, because a lot of them are about tax. Think about, and you can do this by talking to us this evening, or you go to mini pupillage and ask people, but think about how it fits with what you want. Think about whether you actually enjoy the legal side of things or the factual side of things, or whether you like a bit of a mix of both. Think about the types of hearings you're interested in. So I mentioned that we do these, generally our hearings are shorter, which does give a bit more opportunity for, particularly for the junior advocacy. Obviously, if you're on a massive commercial case for 6 months, you're not going to be doing any of the advocacy, but that isn't the case in tax, and it sounds like it's not the case in any of these practice areas too. And think about, do I like statutory areas? Most of you won't have, if you're applying to tax, most of you won't have studied tax, but you might have done something regulatory, or you might have done land law. There are subjects out there which are statutory as well, and have a think about that. And yes, as Olivia says, look at websites and look at resources. I'm here on behalf of the Revenue Bar Association, but I can talk about the resources on my own chamber's website, Pump Court Tax Chambers. We have demonstration interviews where you will get to see me interviewing one of our poor junior tenants. We have explanations about how our process is going to work. We have fuller seminars which just focus on tax, but the same sort of idea as this. There is lots there, and I know there's a lot and it can be overwhelming, but look at those once you've got your applications in, maybe, and you're getting ready for interviews.
Great, thank you. And Sam?
Thanks. Just building on what the others have said, I think it's important to identify where you're applying to a set that practices as one of a very small number of chambers in that area, to identify what distinguishes that set from others that also practice the same area of law. So for example, 5RB is one of a very small number of chambers at which you can practice media law, the only one at which we do purely media law. And so identify what it is that distinguishes that set from other sets at which you might be able to practice media law. Because at some point during either the paper application round or during oral interview, somebody is likely to ask you, why us? Why this set of chambers? And this is an excellent opportunity to demonstrate that you've looked into the chambers itself. And so you give an answer that goes beyond just saying, well, this is why I'm interested in that area of law, and instead can identify, and I'm going to be exposed to whatever it might be within that chambers itself. It might be the number of barristers in the chambers, it might be particular nuances in the law itself, and it enables you to demonstrate sort of a deeper understanding of the law at that early stage. And just, sorry, one very quick thing is to say that one way in which you can do that is just to look at the members of, the junior members of chambers and their profiles online and see what they're doing in comparison to others.
Thanks very much. So all very good food for thought, and hopefully that will be helpful to all of you in preparing for your pupillage applications. Last question then before we throw open to questions. So I'm going to start with Olivia. What support is available for pupils and junior tenants in your chambers or specialist area? And you're a very good person to answer that because you've just been a pupil.
So at Erskine, we have chambers tea every day, and genuinely people come every day and talk about what they're doing. And as a junior member, you can go and, you know, bounce ideas off people, and it allows you kind of keep up with what people are doing in chambers and also to get support if you want it. Secondly, I can say genuinely it is, you know, this isn't just a, oh, we have an open door policy. There genuinely is. I feel like I can go and speak to pretty much anyone in chambers about what I'm dealing with, and people will be super happy to advise you. It's, you know, a tight-knit set, and I find it easy to go and ask people questions. We also do kind of meet on a more casual level than chambers tea. So, you know, drinks after work, and often we go to Hall on Fridays for fish and chips. So that's a kind of potentially less threatening environment where you can easily just, you know, bounce ideas off people. And then also we have support staff, as you know, all chambers do. So there's the clerks, and there's people to help you with, you know, your tech and accounts and that kind of thing. So, you know, if you kind of open up yourself to using and speaking to people in chambers, then you are very much supported. And when I say that, I genuinely feel that.
Thanks very much. Sam.
So at 5RB, just taking in sort of stages of pupillage, tenancy and onwards. During pupillage, of course, your primary point of contact is your pupil supervisor, and you have a strong interpersonal relationship, or at least you ought to, and I always did, thankfully. And so there's that sort of network at that point. And also, if you're taken on as one of 2 or more pupils, you have the ability to speak to each other about anything you might be facing. Pupillage is a very stressful time, of course, and so it helps to have somebody else to discuss it with. But if you're one of one, there are, of course, other junior members of chambers who've been through it recently, so you can talk to them. Then once you're taken on immediately as a tenant at 5RB, you're assigned a mentor, so somebody more senior within chambers. That enables you at the very, very early stages to run pieces of work by them, get their advice on that, but also discuss tactics to do with cases. Any sort of pastoral support you might want to seek from them, they can provide that to you. And then, as Olivia said, we also have a very strong collegiate atmosphere within chambers. It helps when everyone is practicing essentially the same areas of law and is very interested and invested in the law itself. We also have, I don't know how long this tradition has been running, but certainly it ran for my co-pupil and I. It happened with people above us, and it's happening for the 2 tenants that have just been taken on. We will sit for about 6 months in the room of one of the silks. And that both enables chambers to identify where they're going to put us, because chambers is running out of room, but also in a more practical sense, it gives you the opportunity to talk to much more senior members of chambers on a day-to-day basis that will get you involved in work. I had an unlimited number of stupid questions, which were easily answered and answered in about a second. But there was somebody sat there almost every single day to the right of me, who I could turn to and say, Adam, I'm so sorry. I know that the answer to this should be at the front of my mind, but what is it? And he was there. So that's fantastic. And then, so I'm now about 18 months into practice. I don't have the lovely security net of being in a room with Adam anymore, but I do share a room with another junior member of chambers. We have, to an extent, an open door policy in that you can't and probably shouldn't talk in detail about your cases, because the chances are you might be instructed against somebody else within the building. But members of chambers are always open to discussing, at least in my experience, and at a high level of generality, thorny legal issues that you might have, or more prosaic matters like what to do with tax bills and chambers rent and all that sort of stuff, which at the early stages might not be so obvious and also might not be clear who you want to talk to about.
Thanks very much. Jonathan?
Yeah, it's very similar at the IP barn in my sets. There is generally an open door policy. I don't think until if you've done minis, you may have seen it, but I don't think until you're in chambers, you quite realize how much discussion there is amongst member chambers about stuff. IP, like Sam was just saying, we're often against each other. The IP, there only are a handful of sets that do IP. It's quite small, but generally once you know who is on which side, you will go and discuss cases with other people, obviously bearing in mind your professional obligations, but there's a lot of discussion that goes on running through tactics, and having the open door policy makes that very easy. And then one thing I've started to do recently is, well, Chambers tries to do, and I'll give an example of how I've tried to do it, is we recognize that there's not only the legal, technical law, substantive, practical stuff, procedural stuff that we can help the more junior members with, but there's also helping them build up their own practice, the marketing side. And if you don't have that, it's very hard to build up a practice nowadays. So we ensure that our pupils, for example, come to our seminars before they've even started pupillage. So they're already being exposed to the solicitors that are hopefully going to instruct them if they get taken on. We bring them to marketing events. We had one up in Manchester in December, and the pupil is paid for to go up and go to that. So the pupil is there with the people that, God willing, they will be instructing him. In this case, he's sitting at the back. That's one example. And then another thing that I've started doing is, if a pupil has contributed more than normal to a skeleton argument, for example, I now footnote that at the very end of the skeleton argument, so that the judge and the solicitors and the clients can all recognize and see their name, because name recognition is ultimately how we build up our reputation. So even small things like that, putting a footnote to say, you know, Becky Nott or Joseph Kay helped contribute to this skeleton, means the judge knows that there's been somebody else involved. They recognize the name. 6 months later, they might be in front of them. So just little things like that through to an open door policy help them build their practice on the sort of more marketing side. And that's also very important, something we do try and emphasize.
Thank you. Finally, Laura.
Yeah, so I think there's a lot of similarities between all of us, and I think this is an advantage. Someone mentioned earlier, maybe Olivia, that being in a relatively small set can be a really great thing. We're about 35, I think, now. So that's wonderful. We also have a mentoring scheme. We have mentors for our pupils, so they have someone to go and talk to other than their pupil supervisor. And then we have mentoring after people become tenants, together with a panel of people that you can go to. So you've got a range of specialists to go to on any particular topic. At the Revenue Bar Association, we now have a new mentoring scheme, because we recognise that one of the issues of being in a smaller set is that you can't always find the person who might have experienced what you've experienced, or have some knowledge of the thing that you're worrying about. So if you want to go and find someone, you know, a senior woman who's had children and figured that out, we can send you to someone. Or if you want to find someone who struggled with mental health issues, there are people who volunteered, say, I'm happy to talk about that side of things. We've got the full range of everything. Generally, you will see we've got all the pupillage details in the handout, which you'll have received by email, and lots of the tax sets, possibly even all of them, will offer financial support during your first year or two. So that might be a guaranteed earnings scheme, or it might be a loan scheme, and so on, because cash flow can be difficult at the beginning of tenancy. And again, that's an advantage of being in one of these sets where your earning potential is good, that these sets can afford to do that sort of thing. Also, we do the Revenue Bar. We now have a moot for junior barristers, so that they appear against HMRC people who want to do this sort of work in front of real judges, so that you've got someone who knows you, and much like Johnny was saying, that you get a judge who recognises you, or a judge who can give you a reference, whatever it is. So that's really great. And also we do have a pretty decent amount of lead work, both in the advisory and litigation side, which is a really great way of building up your practice. Again, that's my set, but it will be true for much of the tax world. So I think there's a lot of stuff. We also have you have Chambers tea, we have Chambers coffee, I think at different times of the day. But in addition to our Chambers wide coffee, we have a specific one for juniors so that you can go along and ask the really, really stupid questions that no matter how nice every silk in Chambers is, you don't want to ask. And I still remember my days of being a new barrister and desperately texting a friend in other chambers to say, do you stand up or sit down in the county court? And what do you call them? And you know, I still do that. I still say to someone, oh gosh, I haven't been in this court for a while. What do I do? We still get it wrong. I still call people the wrong thing all the time, but it's just nice to have that really easy access to that kind of silly stuff. And I think our juniors tea and mentoring and all these sorts of things can really help with that side of things, that the stuff you worry about.
Thank you all so much for your very thoughtful answers to all the questions. Let's throw open to questions from the audience. And do we have any way of getting on online questions
No,
or not?
I failed on that front. I'm
Oh,
afraid.
no, okay, well, okay, so if you're here, you can ask questions. We've got a roving mic. Yes, one gentleman here.
Yeah.
Hello, first of all, tax law is the best law. I wanted to ask a question to the entire panel here. What case decided during your lifetime has defined your area of practice the most? Now, that's a big question, I know.
I'm going to start with you.
Hamilton News Group newspapers, when there was, when I came to the bar, there was no law of privacy. And now there is, and it's virtually all we do in terms of privacy law. It's taken over libel law, and that's a complete change in the law since I came.
Oh gosh, it's a difficult question. I think I'd have to say the tax avoidance line of cases. And so if it has to be one in my time of practice, then it would be UBS and Deutsche Bank. Just a line of cases that talk about how tax law shouldn't, well, all law should not be interpreted literally, and you look at the purpose of the legislation and take a realistic view of the facts. And that has really turned the tide in tax planning in the time I've been in practice.
Olivia.
Probably, I might be pronouncing this right, Salomon and Salomon, which is it was a case about essentially a one-man company. And so, and it essentially established that, you know, even if it's a one-man company, it's still a company. So it kind of reaffirmed the fact that the corporate form is a very important and specific body separate from the people behind it.
Jonathan.
I think for IP, there's obviously very different areas, but I would pick one example in copyright, which is a decision of the Court of Justice in InfoPac, where they decided that the InfoSoc directive treated copyright in a way that the InfoSec directive doesn't. And there was a line of cases that came off that our courts have recently now started to move away from. But that's definitely had the biggest impact because it's expanded copyright on an EU basis, which we were involved in. And now there's finally we are diverting back.
Thanks very much.
And there was a question down here.
Oh,
Hand up down here.
Was there a
before.
hand up down here?
Yeah,
Yes.
right.
Do you want to just wait for the microphone? It's a lady at the front.
He didn't know he was signing up for this job.
Not my own job.
This is a question for the entire panel, but I was wondering, when you first began practicing, what skill or area do you think had the highest learning curve?
Who wants to start on that?
I'll go.
You go on.
I would say oral advocacy. I'd done a lot of mooting, I'd done a lot of debating, I did MUN, I was, you know, won a national mooting competition. So I thought that I knew what that was about. And then when you get into court and get real advocacy, you realize it's a totally different game and something that practice makes you infinitely better at. And the level of preparation, again, you don't realize how much preparation, as Laura mentioned earlier, weeks of preparation can go into one day in court. And that is the thing that I thought that, you know, I now go in with very detailed, almost full scripted notes. I don't use them because I've written it and in my head it's all been practiced out, but there is almost a verbatim script in front of me in court. And when I started in practice, I thought, oh, I could just do what I'd done before and have detailed notes or short notes. And then I saw Henry Carr, QC, have a full script, and I thought he is brilliant and he's doing it. And then I realized that, and that I think is the bit that surprised me. There's an awful lot more preparation and practice that goes into really good advocacy than you realize until you actually are doing it.
Olivia.
I think, well, obviously there's kind of a distinction when you're kind of practicing unled versus led. And I think the main thing for me, because we're, you know, I'm very at that stage, I think that when you have your first set of unled instructions and you're kind of like, right, now I'm actually kind of in control here. I'm like, you know, the tactical decisions and those kind of practical matters, because I feel very comfortable with the law side and, you know, and during pupillage you feel very tested with that, but there's a different experience when you're kind of like given the instructions and now this is yours. And that kind of feeling has been, I think, the biggest learning curve. But as I said, I feel very supported in Chambers that I can go and speak to other people with experience, and particularly the junior end has been very, very helpful because they have that kind of practical experience in the court that you're in, and they are very willing to help you and advise you when you're making those tactical decisions that feel a bit scary at first, but really you're very able and competent to do, because that's what pupillage exists for. But there's just that kind of feeling when you're the one actually doing it, but it's also a good feeling because you're like, wow, I'm doing this job now, you know, great, because that's what you've worked for. Laura.
I think this overlaps with what Olivia was just saying. It's the tactical, but it's also the client handling side of things. We all spend our law degrees or whichever degrees we're doing in GDL learning to figure out the right answer and tell someone what the right answer is. But you very quickly learn, although you have to learn lots of techniques of how to deliver that to your client. Because if you have a client who thinks they've got a brilliant case and they turn up and you say, so my headline is you're going to lose. Then you've lost them completely, and they're not going to listen to a thing you say, and they're going to be really defensive and argumentative. If instead you say, it's really interesting how this case has developed, and I can see why these arguments were run in the way that they were, but now that we've got the evidence, they look a bit more difficult, and you know, we'll think about some other arguments, but ultimately, I think this is a very difficult case for you to win. Then your client is much more likely to listen to you, to engage, and to think creatively about ways forward. And it's the same if you're doing it on paper. You know, saying my instructing solicitors have made this point in the instructions, but it's wrong. You're never going to get a set of instructions from those solicitors again. But you know, when I'm a supervisor, I see this, and it's not because people are doing it wrong. They've just not been taught that side of things, and I think that's a really interesting thing to learn. And you pick up, you know, as Johnny was saying, you learn from the silk seesaw in action. You pick up totally different styles from different people, and you pick the ones that work for you. And so you keep learning about that for the rest of your career, I think.
Aidan.
Steepest learning curve for me was learning to make cost submissions, because you go through pupillage being led or following people of significant seniority, doing very, very interesting cases, fantastic points of fact and law. And then suddenly you're in court on your own in front of a master, and you realize the only thing your client cares about is getting their costs and not giving anyone else any costs. And it's a sad reality, the fact of civil litigation, that's what it often comes down to at the end. And when you start out as a junior, it'll be your job to go and mop up whatever's happened in a case and get your client out with as little financial damage as possible. So it's a very different skill, and you need to learn it quite quickly once you get down to the nitty-gritty of junior practice.
It was really funny because I was just thinking about the first hearing that I did, and it was a cost application. I was a total muppet. I hadn't got a clue what I was doing. I made a hash out of it. I went outside and I had a little cry in the corridor. And that was the last time I went into a hearing, so unprepared and so clueless. And I think your first hearings on your own are really, really difficult. I think being rather better prepared than I was is a good start. But asking those around you for help, and I think again, I didn't ask for as much help as I should have. And what I'm getting from all of you is that there's a lot more help and a lot more awareness of helping junior barristers, and not just throwing them out to go and say, just go and deal with this application in the county court. Here's a set of papers. It doesn't really happen anymore. You get a lot more support in your early years than I think was the case a few decades ago. So do we have any other questions? Yes.
Yes. This might be related to the previous question, but are there any skills that are specific to your specialist area that barristers need to acquire or need before whilst working and engaging with the bar?
Do you want to start?
Yeah, I can start. I think a lot of people view tax as very complicated and it's certainly very detailed. And I think one of the biggest skills of being a tax barrister is being able to distill that complexity down to the key issues and explain the answers to those simply. So yes, the art of simplifying the difficult, I think.
Olivia?
I've had experience of a few different areas of law because I was a judicial assistant beforehand in the kind of in both commercial court and chancery division. And I think that there is overlap in the sense of when you're applying the law, there's overlap in those skills fundamentally. And, you know, having a good attention to detail and, you know, not missing things. So I think that there's probably a big overlap. And I think that from what everyone has said here this evening as well, I think I've seen more overlap than I maybe was aware of. I'm not sure there's anything I would say specific you essentially need to have just specifically for the company law area. But I guess with the statute, you need to be very willing to engage with the statute. So, yeah. Aidan?
In libel law, we have this strange thing called the single meaning rule, which says that even though everybody who reads a newspaper article or book will go away with it from it with a slightly different meaning, for legal purposes, it just means one thing. What means one thing, and that's what the normal, ordinary, reasonable reader would draw from that. You have to plead that, then you have to argue it, and the court will decide what the meaning is, and that will often make or break a case. If you can develop the skill of pleading a good, pithy meaning that really captures everything that's nasty and defamatory about an article or book in a few sentences, in a way that will hold it all the way through to trial and argument, that's a great skill to develop.
Thanks very much. And Jonathan?
I think this applies to a lot of areas, but it arises in certain areas of IP particularly, which is there's a tendency amongst many barristers, if not all barristers, to try and show off and show you've come up with lots of clever arguments and you want to show it to the client, you want to show it to the court. But the reality is you're very unlikely, you know, not all arguments are created equally. And the skill is to try and work out which ones you need to spend your time on. If you've got 1 hour in court, you're better to spend 20 minutes on 3 good points than, you know, 10 minutes or 6 minutes on however many points. It doesn't mean that your 10th best point is not going to win. Sometimes you do win on that. But again, I mentioned Henry Carr earlier on. I remember him telling me, if you can't win on your 1st, 2nd or 3rd point, why are you going to win on your 9th, 10th or 11th point? And there's a lot of truth to that. And there is a real tendency, particularly when you're junior, to want to show I came up with all these points. And it arises in particularly in copyright, because there's so many defenses and exceptions. You could almost argue every defense. And I've seen that. I've seen every defense in copyright put to me as a possible way out, when actually you need to distill it down because you don't have that much time in court. You don't have that much time on paper. And that, I think, is a real skill that applies across all areas of the bar, but it requires experience and ultimately it requires confidence, because you have to work out, I'm going to ditch these points because I think these are my best ones. But that comes with practice. And I think that's something that you keep developing as you go on, but the sooner you can develop it, the better.
That also ties in with what Laura says about client handling, because you also have to tell your clients that you're not going to run points 8, 9 and 10. And that's sometimes the hardest thing about it. Thank you very much. Well, look, it's, I think, time to go and get some refreshments, but we can continue the conversation there. Please do come and talk to the panel members, ask them questions. Come with all those burning questions that you were too embarrassed to ask during the last 10 minutes. There is no question that is too stupid to be asked there. Everyone is here to answer your questions. And hopefully you'll go away with a lot more knowledge than when you came in. Thank you very much to all the panelists, to Sam, who's left, but who very helpfully answered the questions on the discussion topics earlier on. And I've been asked to say that, as you'll have seen, that there are pupillage and scholarship interviews going on in the building. So please don't lurk around those, but just make your way straight to the drinks. I'm sure we don't need much encouragement to do that. Thank you very much to everyone, and see you in the drinks shortly.
Thank you.